welcome to my channel. My name is Diana Romanovska and I am a certified family law specialist practicing family law in San Francisco. Today I would like to talk about limited scope representation. What is limited scope of representation? It is actually the opposite of full representation, meaning where a lawyer is fully on the record. When an attorney is fully on the record, it has consequences. The first is that the other side is no longer allowed to communicate with a client directly. And when I say the other side, I'm not saying the other party. The other party could communicate, especially if they have children, they have to communicate, but I'm talking about the other firm, the other lawyer. That being said, the second limitation is that the lawyer who is fully representing a client is responsible for all deadlines in the case, communicating with the court, communicating with opposing counsel, and handling the case fully. And now limited scope is where a lawyer and a client agree that they only going to have the lawyer handle a specific task. It could be just preparing documents for a motion or something else. And when that happens, there are two types of limited scope representation. The first type is when a lawyer is noticing the other attorney and the court with a form, FL 850, and says, here I am, I'm representing this client on that limited scope. And that form needs to be filed and served to the other counsel. Then the other type of limited representation is unnoticed, meaning let's say attorney is being contacted by a client and the client wants to draft, needs help with drafting an offer letter or something like that. Then the lawyer doesn't need to notice everyone and helping the client to draft the letter and the client proposing to the other side, represented to unrepresented, that letter. Now, how to complete the scope? There are two times to complete the scope. One type is when a client signs a substitution of attorney and the lawyer signs it, or at any point in time, or when the scope is actually completed, then the lawyer files notice of completion and serves it to the other side, and also drafts another blank objection, meaning sends the client objection form where the client has 10 days to object whether the scope is completed or not. And then another limitation or requirement for the lawyer to file this completion form is the lawyer has to file all the documents and related to this appearance. For example, if the court made an order, there is a finding order after hearing that the lawyer needs to prepare and file. So typically the way it works in, let's say San Francisco court, the judge makes a ruling and then two lawyers are sitting in front of the judge and the judge is asking who's going to prepare the finding order after hearing. Basically what judge just ruled in writing that needs to be prepared, and it's called finding order after hearing form FL 340. And then if that's the lawyer who was in limited scope representation, that lawyer needs to prepare it and send it to the other lawyer to sign, and then file it with the court. And then the lawyer can actually file a completion notice. If at any point in time the client doesn't want to relieve the lawyer from the record because, let's say, scope is not completed or whatever, then the lawyer can file a withdrawal motion and ask to be withdrawn from the case. And that has to be stated and why, and there is a hearing about that for another video. But as to the limited scope representation, I think I covered the basics. All right, I hope that was helpful and I will see you soon. Bye.